The concept of Sunnah in the Muwatta of Malik ibn Anas, Mohammed Yusuf Guraya, Mcgill, 1969, Montreal, Canada. In other words, the Sunnah of the Prophet as a non-verbal standard of conduct introduced by the Prophet was present from the beginning, but as an explicit legal term was defined by Shafi'i, though he maintains that the term was introduced into the theory of Islamic law, presumably towards the end of the 1st century by the scholars of Iraq. Otherwise, it would be hard to resolve the contradiction by means of which Professor Shat maintains on the one hand that 1. The basic function of the Prophet was to establish moral norms and to introduce religious and ethical principles to the Muslim community. 2. These norms and principles replaced the ancient Arabian standard of conduct and represented a radical breakaway from the Arabian paganism. And 3. This activity of the Prophet was followed by the companions and the early qadis and specialists, and on the other hand, that the Sunnah of the Prophet suddenly appeared in a Shafi'i's work without having any conceptual connection with the Prophet. 7. By the time of Malik, enough material had been created by the authoritative pronouncements of caliphs, by decisions of judges, and the commands of civil and military authorities to make the concept of Sunnah a living reality. In turn, this whole material took the place of the pronouncements and decisions of the pre-Islamic authorities and became the basis of practice and customs of different regions of the Muslim domain. Thus the fluid and liquid concept given by the Prophet began to crystallize in the shape of definitive rules and usages of the community. In this way, the old idea of Sunnah, i.e. the actual practice established over generations, reasserted itself, and the people began to take much interest in the past material and the material creating agencies, caliphs, companions, judges, commanders. Once this interest in the past and investing it with the supreme value was aroused and set in motion, there was no power to check it from its culmination until the time of Shafi'i, who argued with full vigour in favour of the tradition, and the coming generations followed him in this respect. However, distinction must be made in this regard between the attitudes of the masses, who were naturally inclined towards what had happened in their recent past, and between the attitude of the responsible men of opinion. The latter were constantly and vigilantly on watch to see, firstly, that the past practices still conformed to the exemplary conduct of the Prophet under the rapidly changing circumstances, and secondly, to ensure that there was no religious and moral objections to the newly emerging transactions and modes of behaviour. Under the Umayyads, this function was entrusted to the Qadis, who used to give judgments making the letter and the spirit of the Qur'anic regulations and other recognized Islamic religious norms into account. Later, this function was taken over by the legal specialists, whose main concern was to see whether the customary law conformed to the Qur'anic and generally Islamic norms. These pious persons surveyed all fields of contemporary activities, including the fields of law. They considered possible objections that could be made to recognize practices from the religious and in particular from the ritualistic or ethical point of view, and as a result endorsed, modified or rejected them. They impregnated the sphere of law with religious and ethical ideas, subjected it to Islamic norms, and incorporated it into the body of duties incumbent on every Muslim. They provided guidance to the masses how to act according to the tenets of Islam on the one hand, and often criticized, though not by political means, the acts and regulations of the Umayyad government on the other. With the passage of time, the groups of the earliest specialists developed into the ancient schools of law, though there existed among them a considerable body of common doctrine based on the religious and moral principles. The general character of these schools was conditioned essentially by geographical factors, local variations in local conditions, customary laws and practices. An important aspect of this activity of these early jurists was to depend upon their responsible personal free-thought activity, which was called rai, or personal considered opinion, for elaborating the religious and moral principles into specific codes of human behaviour. Fazl Rahman says, this rational thinking produced an immense wealth of legal, religious and moral ideas during the 1st century and a half approximately, but with all its wealth, the product of this activity became rather chaotic, i.e. the Sunnah of different religious regions, Hijaz, Iran, Iraq, became divergent on almost every issue of detail. Scholars such as Awza'i, Abu Yusuf and Shaybani and Shafi'i have left details of the legal differences of the period, but the best description, which is very brief but comprehensive in this regard, has come down to us by an Abbasid official dignitary, the Secretary of the State, Ibn Muqaffa. Ibn Muqaffa states, Among these issues which Amir al-Mu'mineen, the leader of the believers, should take into consideration in the matter of these two cities, Kufa and Basra, and of the other provinces and regions concerning the differences of these contradicting legal problems, the diversification of which has become a great issue in connection with the blood, marital relations and properties. The blood and marital relations which were permitted in Hira are prohibited in Kufa. The same kind of legal diversification is happening in the middle of Kufa. A thing is being permitted in one locality, but it is being prohibited in another. In addition to this diverse legal activity, judgments are being given regarding the blood of the Muslims and their honour. These decisions are given by the judges and are enforced by the government. In the face of all this, there is not a single group among the people of Iraq and Hijaz who perceives this situation. Rather, they take pride in what they adhere to and pour scorn at what others possess. This attitude of theirs has thrown them into a situation which perturbs anyone who hears it from the intellectuals. It is at this historical junction that Malik ibn Anas comes into prominence, both in official and private capacity. Abu Ja'far al-Mansur, the second Abbasid Caliph, no sooner did he get an opportunity after maintaining peace and order throughout the domain than he took into consideration his secretary's advice and approached one of the most venerated personalities of his time, Malik ibn Anas. He requested him to help him in this crisis. There is enough historical evidence to support the view that the Muwatta was produced in compliance with Mansur's request. The Abbasids were in a desperate need to find some middle path which would put an end to legal divergences, and the Muwatta of Malik was intended to meet this desire. Apart from the Abbasids' request for standardization, there was an independent movement for uniformity and standardization launched by the intellectuals themselves. Ibn Hajar al-Asqalani and az-Zurqani have mentioned many scholars in different regions who compiled treatises on legal thought developed in their respective regions in Medina proper. It is said that some scholars compiled works, namely al-Muwatta, before Malik. The pressing need of the time for uniformity, accentuated and brought into focus by political revolutions, social upheavals and legal divergences, compelled the government as well as the intellectuals to meet the challenge on an empire-wide level, as the previous scholars had done on the regional level. It is our contention that Malik was inspired by both currents, regional as well as ultra-regional. The Muwatta, the work he produced in this context, contains the elements of both, and it is a true representation of the movement of the time. It diverges from its predecessors in the sense that it gives importance to the hadith to the extent that it opens every chapter with a hadith. Again, it is our contention that the introduction to the hadith in the Muwatta at this time was due to the popularity of the hadith. This contention seems reasonable because the hadith was acquiring the status of a universal element acceptable to all regions. This is in contradistinction to the pure fiqh, which later developed in geographically closed areas. In al-Muwatta, Malik introduced this new element to satisfy the universal aspiration, but it remained true to the genius of its predecessors, to the extent that the overriding authority accepted by him was not the hadith, but the sunnah. End of chapter 1. Stay tuned for many more parts.